Live from Chattanooga, Tennessee, it's Nooganomics with David Tulis. This is David Tulis. We're brought to you by Superior Air Systems, the HVAC company with the bright orange vans in the Chattanooga area. Superior Air Systems, 886-6602. And also, since we are talking about, we have been talking about the marketplace and the Fed's artificial suppression of the rate of interest, the signal of future value. We have artifice there, great danger, and no doubt further turbulence and continuing malinvestment in the marketplace. If you have questions about your investments, contact Patrick Neal. Patrick Neal is the Edward Jones broker here in Hickson. His number is 870-7894. That's Patrick Neal, the Edward Jones broker to talk to, 870-7894. And I've had long conversation with Patrick, and he's a very sound family man. He's a homeschool dad and very conservative. Edward Jones is the largest privately owned brokerage house in the country and is not under the kind of pressure that publicly traded brokerages are. You will not be churned as a client of Patrick Neal. Also, just wanted to remind you that if you get a pizza from Raphael's Pizzeria, an Italian restaurant, you get a standard issue bit of inflation, if you will, and that's this. You buy one pizza, and wow, you got two. Okay, so you buy one, and you get one pizza free. In addition to that, there are 3 outlets for Raphael's, a great local economy player, local restaurant. I've got a few questions. They are questions for Herb Moncier, who is a criminal defense attorney with a long practice in Knoxville. And Herb Moncier on Tuesday spoke before an assembled host of journalists and activists and county commissioners and librarians and other archivists and county clerks and others who are concerned about and have an interest in a proposal before the Tennessee General Assembly or Study Committee that would effectively tax you, my listener, for your access to public records. And Herb Moncier, what does my listener need to know about what was said generally Tuesday in Knoxville at this hearing, one of 3 going on this week in Tennessee? What was being discussed, and then tell us what your position is or was at the time.
David, generally I think 30 people spoke in Knoxville. I read in the newspaper maybe 50 spoke in Nashville, and I believe there's a hearing going on in Memphis at the present time. And the issue was being dealt with by what's known as the Tennessee Open Records Council for the state of Tennessee, a agency set up a number of years ago to basically monitor open meetings requests, open records requests throughout the state. Miss Ann Butterworth, I believe it is the counsel for that particular office. Earlier this year, it's my understanding that this came about because of a request that was made by a gentleman in Loudoun County, Tennessee, for a number of records pertaining to a county commission rule that had been adopted. And Loudoun, for whatever reason, chose to send his request to their private attorney that had been hired to represent the county. The private attorney apparently reviewed the documents that had been given to him and ended up sending the county a bill of some $7,000 or $6,000 at $250 an hour to review the records before this man got the records. And Loudoun County screamed foul and got the attention of some legislators who considered or have either introduced a bill to be considered in the next legislative session as to whether or not to charge citizens fees for providing records to be inspected by the citizens. Now, David, the key words here are the difference between an inspection and getting copies of records. The rule in Tennessee to date has been that a person can make a request to inspect records, and those records must be produced to the person for them to inspect them. If the person requests copies of the records, then under the current Tennessee law, the agency can charge a reasonable fee, and there's a schedule of reasonable fees for preparing those copies. And those such as myself who often use the public records provisions have found that many people who are custodians of the public's records in this state, for some reason, feel those records belong to them. And they don't want private people, particularly private people who may not share their interest in examining the records, or may wish to do so with a critical view of people that are in government. They throw up roadblocks wherever possible. And this cost of copying has been a tool that has been used. And although the copies, I think the reasonable copy rate is 15 cents a page, maybe it's gone up to 20, I'm not sure what it is right now. But they also can charge a hourly rate for their employees to assemble and to copy the matters. And that quite often becomes very expensive. It certainly becomes very expensive to a citizen who is simply being a watchdog or a public-spirited citizen who is trying to determine what their government is doing. So this problem with regard to copying, and I want to emphasize the word copying again, has been a roadblock and has been used to discourage and to prevent people from broad access to copies of public documents. Now, those in government who feel that they're being burdened by allowing the people's records to be examined by the people have continued their efforts. For example, many agencies will not permit a person to look at a record and take a photograph of it with their cell phone. To do. Or in my case, I always, when I go for an inspection, take with me a portable scanner and I scan the records. Well, they won't let you do that. Why is uncertain, and that's sort of an unclear area right now. But what they're doing is they're using the cost issue. That is, you've got to pay to carry something out of that agency, and you can't do it through modern technology of either sticking a thumb drive in a computer and downloading it onto a thumb drive, or scanning it, or making a Xerox copy. You can't do that, or printing it off of a computer. And it's nothing more than this bias, if you will, against people that public officials, some public officials, and I want to emphasize that, have. Now, David, my point of view that I expressed Tuesday evening was completely different, I think, from the other 29 people that spoke. And it has been my position as an attorney, and particularly an attorney who has been involved in extensive litigation for the public's interest and the people's rights to know and the rights of the people under the constitutions of the United States and the Tennessee Constitution. That's where my practice has gravitated toward. And so my presentation was not whether it is wise or needed to charge people for the other part of the Public Records Act, and that is to simply inspect the document. Until this issue came to the forefront in Loudoun, if a person or citizen wanted to only inspect but not copy public records, then they were entitled to do so without charge. That is the issue that is proposed by the current legislation, and that is whether or not public officials can charge individuals and the press for simply inspecting public records. Now, the 29 other people that spoke, of course, said that this is going to be nothing more than a pretext by which you get these huge bills for the right to go in and look at the records. And they were very well spoken. They made very good presentations, and I wholeheartedly support what they said. However, I presented something that apparently no one else has looked at, and that is the Tennessee Constitution. We often, in this day and age, completely ignore the constitutions when it's convenient for people who are in the power of government. If they don't want to deal with something, they just ignore the Constitution. And Tennessee has done that with its Public Records Act.
Are you saying the Public Records Act has a problem already? This is David Tulis. We're talking with Herb Moncier, who's a Knoxville attorney with a long criminal defense practice and kind of a special interest in the Constitution. Herb Moncier, are you saying that in a nutshell, is there a problem with the current Open Records Act in Tennessee?
Absolutely. The Public Records Act is a misnomer. The Public Records Act is really a confidential records act. While it says that the public records of Tennessee shall be open, it then goes out to permit every agency in the state of Tennessee and list multiple exemptions that make records confidential that nobody can keep up with, and allows agencies to make their own records.
How many exemptions are there?
In violation of the Tennessee Constitution.
How many exemptions are
there? David, I want to read to you, as I did to the people Tuesday night, what my position is.
Go ahead.
And I'm reading to you from Article 1 of the Tennessee Constitution, which in Tennessee is the Tennessee Bill of Rights. It is substantially different from the federal Constitution Bill of Rights contained in the first 10 amendments. Now, I am reading to you verbatim Article 1, Section 9 of the Tennessee Constitution, and it says,
don't miss a word.
Freedom of speech and press, that the printing presses shall be free to every person to examine the proceedings of the legislature or any branch or officer of the government, and no law shall ever be made to restrain the right thereof. That's what our Constitution says.
Well, all right, that seems self-evident.
The Public Records Act restrains the right of the people to what they gave themselves in Article 1, Section 19. You cannot read Article 1, Section 19 and not come away with the conclusion that the people of this, that our forefathers, the people, gave to the people the right to examine the proceedings of every agency in the state of Tennessee. Now, that's not in the federal Constitution. And furthermore, not only did they give that right, they then said something that you very seldom find, and no law shall ever be made to restrain the right thereof. Now,
so what you're saying is the Open Records Act is
putting it to the current legislation, and that is to charge for the right to examine, that is, the right to inspect government records. That's a law restricting that right that is strictly prohibited by the Tennessee Constitution. The Tennessee Constitution says that the right to examine shall be free. Now, the word free, of course, is a word that may mean free in the sense that you could do it, or free in the sense that there's no charge for it. But either way you cut it, any law that basically taxes the people or charges the people for the right to exercise their constitutional right is a right that restricts that right.
Is an authority that restricts that right.
So, David, it was my view Tuesday night. It is my view today. It has been my view that we're debating the wrong thing in these debates that are going on. While we have all of these wonderful people debating the wisdom of charging for a constitutional right, they should, in fact, be debating whether or not the Constitution prohibits the legislature from doing what it's considering to do. There's where the debate should be, and there's where the litigation is going to be. Now, some people may try to twist the words of Article 1, Section 19 to whatever agenda they may have to try to tell us as the people that it says something that it doesn't say. You know, sort of like we listen to a presidential debate and then we have people tell us what the people said. I mean, it's right. So we can't listen to what they said. We have to have spin doctors tell us what they said. Well, you know, they exist in all forms of our current government and certainly exist with regard to politicians and the legislature when they want to do something to take one of our rights from us. But let's listen to this, and this is the second thing, and we'll wrap up here in a minute. With regard to the right I just read to you, and that was verbatim out of the Constitution, there is another right that's just not talked about in Tennessee. The courts don't talk about it. Government doesn't talk about it. And it's Article 11, Section 16. And this provision of the Tennessee Constitution is again not found in the federal Constitution. And what it says is the Bill of Rights to remain inviolate. Now, keep in mind, Article 1, Section 19 is a Bill of Rights in Tennessee. All of the rights in Article 1 are Tennessee Bill of Rights. So, what our Constitution says is follows, quote, "The Declaration of Rights hereto prefixed is declared to be a part of the Constitution of this state and shall never be violated on any pretense whatsoever. And to guard against the transgression of the high powers we have delegated, we declare that everything in the Bill of Rights contained is accepted out of the general powers of government and shall forever remain inviolate."
What does the word accepted mean?
They don't have that power.
Okay, so accepted means cut out from, not included.
We created a government in Tennessee that consists of three branches. The executive, which is our governor, the legislature, which is the House and Senate, and the judiciary. We created that government. The people created that government. They then turned around and said the Bill of Rights that we have made and given to ourselves cannot, under any pretense, be taken from us by the branches of government we created. They don't have the authority to do that.
So Herb Moncier of Knoxville, you're the Knoxville criminal defense attorney. You're saying that the General Assembly, by the Open Records Act, has taken from the people their right to have full and free access to all the government's documents, all the government's secrets,
inspect,
if you will.
To examine.
To inspect.
That is correct. Yes, sir. The Public Records Act was unconstitutional when it was passed. It is a misnomer. What the Public Records Act is the legislature has created exceptions and confidentiality to those records that the people of the state of Tennessee said that they shall at all times have free right to examine, and that no law shall ever be passed to restrain that right. Just overlooked it. Because you see, it's convenient for the legislature to overlook the Constitution. In this case, they don't want to look to the Constitution because they want to restrict the rights of us as the people of Tennessee to access to know what our government's doing. That's the agenda.
We're talking with Herb Moncier. Herb, my presentation was quite different from yours, and I'm seeing and hearing your presentation again. I'm seeing how short my own arguments have come. My argument was somewhat pragmatic. I figured I'd say something that no one else was going to say. I said that the state government is worth $97 billion, which includes the $45 billion slush fund, which is the Tennessee comprehensive retirement system. Together, they're worth $79 billion. And isn't it ridiculous to think that an entity that valuable, that rich, would charge dimes, nickels, and $1,000 bills to citizens like my listener wanting to look at records? You're saying that really is irrelevant. That's an irrelevant argument.
No, David. I'm not saying it's irrelevant.
Well, you're implying that it is, and you're not wrong to do so.
All 29 people that spoke in opposition to this, including your economic analysis, are right on.
Well, but your point is much more fundamental.
Subordinate to the Constitution. If the Constitution prohibits it, we don't ever get into that dialogue.
Exactly right. Exactly right. So in other words, your argument is much more fundamental.
We have been the government. Our government has changed the playing field from the constitutional prohibition to sitting down to a debate among the Davids and the other people as to whether or not this should happen in terms of whatever agenda somebody has. Well, that debate should never take place when our Constitution prohibits it. But they will not debate the Constitution. They will not address the Constitution. And the reason they won't debate it and the reason they won't address it is because they don't have an answer.
Are you planning litigation?
The Council of Open Records Act. Now, I'm confident. I don't know her personally. I have absolutely no view as to whether she does a good job, bad job, agenda. None of that. Strike that out of our discussion. But do you think she's going to address the constitutionality of the fact that she shouldn't exist?
No.
I mean, of course not. All of these debates of all of these committees, these advisory committees, all of the Senate debates, all of the legislature, do you think that they're going to go back and debate and say, hey, wait a minute, this Public Records Act's unconstitutional? All of these exceptions we're talking about, all these charges that we're talking about. Now, once again, I want to finish because I'm sure I've used way too much of your time.
You have about a minute left.
Okay, I want to finish with the point I made at the beginning. There is a distinction to be made between the right to inspect and the right to charge for the cost of a copy. Those are two different issues. And I think that it is appropriate that there be a reasonable charge. If I, as an attorney, go to a clerk's office, I'm going to have to pay for any records I get. And that's a reasonable cost to pay. But for me to walk into a clerk's office and want to inspect, just look at documents, they can't charge me for doing that. I've already paid for it in my taxes. That's what they're there for. They're there to uphold the Constitution. They're there to uphold the constitutional right of every citizen of this state to inspect the proceedings of every agency of this state. All of this TBI secrecy.
Well, her month is turning me today.
Who do I send the bill to?
Listen, how can right quick, how can my listener call you? Give me your phone number or give him your phone number in case he wants to call you with a legal problem. You got half a minute.
My telephone number is 865-546-7746. More importantly, my email address is Moncier, MONCIER, at Moncier Law, one word, no periods,